Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Peter, nice to see you again.
You too, Trevor.
This is probably our swan song for 2025, it being December, but let's make it a good one.
And we were just reminding each other, we've been doing this for 4.5 years, Trevor. Feels like yesterday that we started, hey? But it's been 4.5 years.
It really doesn't feel that long, it doesn't.
Doesn't at all. And you know why? Because it's fun. That's why, because we enjoy doing it.
Exactly. Oh.
And we sort of kept our promise that we were going to do it on a more regular basis. So here we are again.
Yeah, and if I can read from the back of this little book, Peter Dachs and Trevor Emslie produce regular episodes of the Taxpayer Podcast on topical aspects of South African tax law. Their infectious enthusiasm reveals how they take their subject matter far more seriously than they take themselves. I think that last bit is certainly true.
It's certainly true. And today we're talking about some interesting topics, starting off with legal privilege. Trevor,
Yeah.
that is a topic that is widely misunderstood, I have found in my career. Everyone knows it's very important, but they're not quite sure what it is and when it applies. So maybe just to set the scene, there are two types of legal privilege. The one is legal advice privilege, and the other one is litigation privilege. So legal advice privilege attaches to any oral or written communications between a lawyer and client in respect of legal advice. And it applies to the whole continuum of the communication. So, for example, a summary of an opinion or a summary of some privileged document is itself privileged. Interestingly, there was a case, it was about 10 years ago, A Company versus SARS in 2014, where SARS requested the narration on invoices. And the client said, no, that's privilege. It related to tax advice that was provided. And SARS said it's not privileged. And in fact, that was upheld by the court. They said the narrations on an invoice to a client are not privileged because they don't constitute legal advice. And I suppose that's a question of fact. I mean, depends how you describe the work and what sort of detail. But
that was our old friend Ben's Ward, Jay, wasn't it?
I think it was.
It was, yeah.
I think it was. There's a lovely line in terms of like, why do we have legal privilege? And we were just talking about quotations and from judges, and this is a quotation. I don't know what court it was, but it says legal privilege springs essentially from the basic need of a man in a civilized society to be able to turn to his lawyer for advice and help. And I think that's a very apt kind of description of legal advice privilege and why it exists and why you have it in the first place. And obviously it needs to be given by an attorney or an advocate. But this gets a bit murky, Trevor, because you and I, we absolutely, I mean, you're at the bar, you're practicing senior counsel. I'm an admitted attorney. I work for a law firm. So, we tick the box very obviously and clearly. But there's lots of other stuff. Like, for example, what happens if you're a legal advisor, you don't work in a law firm, you work at an accounting firm, or you work in a consulting practice? Or what happens if you're an accountant that happens to work in a law firm and you give advice? Is that subject to privilege?
Of which there are many.
There are many. And there's even nuance around that, because I think there's a non-practicing role of advocates, people who don't do pupillage, but you can just sign up and become an advocate, but then you're not practicing, as I understand it.
Well, some they used to be known as rebels, but all you need to become an advocate is to have an LLB. Then you're entitled to be admitted.
You can be admitted.
Yeah, if you want to be a member of the bar, you have to do pupillage, obviously.
So they won't be a member of the bar.
Yeah.
And there was a case on that was quite interesting, because it says what is part of the reason that you should be admitted is because you should be an office of the court subject to professional ethics and discipline. So, and that kind of makes sense to me, because then that's why you're subject to a regulatory body, in our case, a law society. So that's the first sort of point, is that, not everyone who practices, or maybe has the word advocate attached to their name, may qualify for legal privilege, or their documentation or the advice that they give may not be subject to it. There's uncertainty on a lot of these points, partly because there's not a lot of SCA authority. There's sort of bits and pieces of South African authority on privilege, but a lot of our stuff comes from the UK, interestingly. We take our guidance a lot from the UK, so there's a lot of, if you like, murkiness around legal privilege and the concepts. For example, there was a UK case that said that an accountant who gave legal tax advice, but gave a legal opinion, that opinion was not privileged, which was pretty obvious, I think, not being an attorney or an advocate. But just an example of the fact that that's a UK case. Well, there's a lot of UK case law on this stuff.
I very rarely, I have to say, very rarely get someone in chambers would say to me, can I tell you something in confidence? And my standard reply, which is 100% true, whatever gets said within these four walls stays
Yeah.
within four walls. That's the bottom line.
And I think that's
it can more appropriate to documents and things like that.
Exactly. But I was thinking about it, and you say, why is legal privilege important? And it often is. And I think maybe more in the, you operate in a more rarefied environment, Trevor, if I can put it that way. In our sort of world, where a client comes in sort of looking a bit flustered and says, I need to tell you something. And like they, blurt a whole lot of stuff out around, but a brother, and he's got a trust here, and he went overseas, and he got money there, and I've got money here, and I don't know what I need to do, and I don't know what of this I need to regularize and how to regularize it. So that's that first kind of consultation where they want to know, hang on, what I tell you is subject to privilege, and that's fair enough. They're talking to a lawyer and they're trying to get legal advice, and it might be they've done absolutely nothing wrong. But I think that's where it sort of stems from. And then, as to your point, Trevor, the written opinions that we do, a long detail. If a client comes with a transaction they want to enter into, we write a 50-page opinion. You can use it as a doorstop if you want. But it will reason out sort of the client's position, but it'll often reason out the position SARS may take or may attempt to take. And the client says, I don't want to give SARS a roadmap. If I enter into the transaction, I believe it, I'm going in eyes open. I've got an opinion from you. I've taken advice, but you know what? There's always doubt in tax law, and law is complicated. So maybe SARS takes me on, and I don't want them to have the benefit of your opinion. And now I've given them a roadmap in terms of how they can attack me. So I don't know if you've seen that, but that's something that clients often worry about.
My experience is just often some people, I've done an opinion for someone, and they say, well, can I show it to SARS? And my standard response is, it's your opinion. I wrote it, but it's now yours. You can do what you like with it. Want to show it up to SARS or to whoever is up to you, but it's not for me to say.
And that's an interesting question, because it's not a given that taxpayers don't want SARS to see their opinions, because sometimes they do. They want to say, I took advice and here it is, and read it, and it's positive advice, and I acted on it. Thinking of the coronation case, there was that opinion that was given by Bowman's, and it was given a long time ago, and then nobody could find it. And SARS latched onto that and said, you've said you've got this opinion, but now you can't find it. How do we know an opinion existed? You haven't shown it, first ignoring kind of privilege, but kind of even the existence of the opinion. So, but some clients say, I'm happy to show it to SARS.
Absolutely. On the basis there's nothing to hide,
Exactly. And I think one of the sort of points around that is whether privilege can be waived and in what circumstances it can be waived. And that's something that, because often what happens in practice, we write an opinion, Trevor, we send it off to the client, and then the client sort of flips it on to someone. Maybe it's the counterparty, maybe it's for the purpose of getting a second opinion from an accounting firm or whatever. And the essence around, I always say to clients, waiving privileges, the purpose of privilege is privilege belongs to you because you want to keep things confidential. If you then take your opinion and you send it out to the world, then clearly you've demonstrated your intention. You don't want to keep it confidential. You don't care about the confidentiality. So then you've waived it, and fair enough. But in the real world, especially with emails and so easy to sort of flip things on, the question arises: when do you waive privilege? And I think the first point is that privilege vests in the client. Waiver can be tacit or expressed, but it can be lost if you disseminate it widely. Then it's waived. So you need to be very careful about opinions. And what we do for clients often is, if they want to show it to someone, we say, we'll send it to them or you can send it to them, but under cover of a letter from us saying, I'm sending this to you. It's on a non-reliance basis, and I don't waive legal privilege by showing it to you. And I think that demonstrates to some extent your intention not to waive your privilege.
That's a good precaution.
Yeah, but as I say, there's not a huge amount of law on this. I think the message there is to be very careful around privileged documents and sort of sending them on too freely and too easily, especially without that sort of disclaimer. And then there's the sort of the concept, which is kind of in the context of waiving privilege, is common purpose privilege. Because if we write an opinion for company A and they want to send it up to their shareholder company B, that's a different legal entity. So the question is, have they waived privilege? And sort of common sense tells you they can't. It's part of the same group. And that's sort of a concept. And again, it's a UK sort of concept, common purpose privilege, that allows for communication between interested parties. So not the party you've addressed the opinion to, but interested parties. And there again, the question is like, who are interested parties? How far does that go? Obviously the holding company is a nice, easy example. Can you send it to another advisor? How far does this sort of go before someone can say that you've waived your privilege? And
well, I suppose a good general rule would be to do what you said earlier, to say, I'm showing this to you, but I'm not waiving legal privilege.
Yeah, I think so.
There might be a substance over form thing with that at some point, but it's a good precaution.
I think so. And I'm sort of comfortable sending it to a limited group of people where you can explain why you've done it. I've got another advisor, he or she needs to read it, send it off to them. I need to send this to head office, send it off to them. And you do it all under cover of this letter. But to think about it and to be aware of it, and to always be aware that privilege vests in you and you can waive it, as I said, tacitly or expressly. And just be aware of that. And if you start sending it out too widely, then you're going to have a hard time saying I haven't waived privilege, whatever this document is, whether it's an opinion or whatever it is. So, I think the waiving of privilege and common purpose privilege are two very sort of important elements that we've sort of taken from English law. And kind of in terms of mistakes that we often see clients kind of saying, I want to I've briefed an accounting firm. I'm just going to copy you in on the correspondence. Like magically legal privilege sticks because now you copied in on correspondence. So no, you need to approach us for legal advice. It's legal advice privilege. You need to come to us for legal advice, and then we'll give legal advice to you. And it may be that we need to go and source it from, expert advice from an accounting firm or some other firm, but it must be us giving you the advice. So, it's not good enough just to be copied in on correspondence with somebody who's actually giving the advice, and that person's not covered by legal privilege. So again, we see that quite often, and it's part of the sort of common mistakes, if you like, we see around legal privilege.
Something I haven't thought about, but it's occurring to me now while we're talking, is when the legal process commences. So you're in court now you're arguing your case. And maybe I was recently in the SCA in relation to Rule 32.3. We wanted to introduce a new argument. How does that tie in with legal privilege? Because obviously you're obliged to plead your case. So at some point, I suppose that's a point of disclosure, with what it is that you intend to rely on. You can't keep that to yourself. Well, otherwise you might have to permanently keep it to yourself.
Yeah. And I think because it ties into discovery, and I think that's where the rubber often meets the road with legal privilege and what's privileged and what isn't.
Yeah.
When you're going through those documents and you see something, that's sort of not helpful to your case, but is helpful to SARS's case, that is something that you need to submit or need to discover. But if it's subject to legal privilege, you don't. And so that's really where you have to test, is there legal privilege? Does it attach and have you waived it? And I always say, Trevor, it's very disheartening to listen to our litigation attorneys doing discovery, and they say a legal opinion is not relevant material. It's not relevant. So you don't have to discover it because it's just your opinion. It doesn't matter how proud you are of it and how beautifully written it was and what conclusions you came up to. It's just not relevant. It's not legally relevant because it's your opinion. So on the face of it, discovery, if we're talking discovery, doesn't need to be discovered. A legal opinion doesn't need to be discovered. But SARS often ask for legally privileged documents, and I think that's
I mean, I sometimes get asked, do you mind if you've done an opinion for us and it's going to court now, do you mind if the opinion forms part of the record? And I always feel a measure of discomfort about that because just with human nature, a judge might want to just show to you that you're talking nonsense or whatever it might be. So I always say I prefer not to have my own opinions as part of the record, but it's yours and you can do as you please.
That's the point. It's theirs, and if they think it's helpful.
Which maybe brings us to Section 233 of the Tax Administration Act.
Yeah. What do you think of that, Trevor? Because
that's
an interesting section.
It's hang on, where are we? Is it 223?
Yeah.
Yeah. SARS must remit a penalty for imposed for a substantial understatement if SARS is satisfied that the taxpayer made full disclosure to SARS of the arrangement, was in possession of an opinion by an independent registered tax practitioner that was issued no later than the date of the relevant return was due, was based on full disclosure, and importantly confirmed that the taxpayer's position is more likely than not to be upheld if the matter proceeds to court. So often one will magically find those words at the end of an opinion. The point is, if it's privileged, how does SARS even know that you've got an opinion that would protect them from penalties under Section 203? How does that work in practice?
And you often get into
disclose it.
You do, but you often end up into a loop because SARS says, I want to see the opinion, or if it starts off with a client saying, I got a Section 223 opinion, so you can't impose understatement penalties. And SARS says, really? Show me the opinion. And then you say, no, but it's subject to legal privilege. So you get into sort of this loop. And there's, I don't know if kind of the right legal answer, but the sort of the practical answer, Trevor and we chatted about this before the call, is you can kind of show like the last page or something, or you can kind of, give a response to SARS saying, I'm the attorney, I drafted this, I drafted in terms of 223. And generally, the point is not pushed, but there is something there that's kind of, the two are at odds with each other, if you like. And SARS likes to see opinions. They ask for opinions. They want to see them, and partly for the reason I suggested at the front. I mean, it's a great, if you trying to unpack a complicated transaction, SARS, and you're just looking at a tax return which tells you nothing, and you can get a detailed tax opinion that sets out all the transaction steps, all the parties, and all the analysis. Come on, I mean, that's such a head start for you. Why wouldn't you want that as an assessor? For sure. So, it is something that SARS are very interested in seeing. There's another interesting section, Trevor, which is section 64, which is where there's search and seizure. So when SARS come and do search and seizure, and you claim that something is subject to legal privilege, then section 64 of the TAA sort of sets out the roadmap for how that's done. And SARS have to, I think, arrange for a legal practitioner to be present during the execution of the warrant, so that independent legal practitioner can kind of say, yes, this is privileged, no, this isn't privileged. So it kind of needs to make a call on the spot, I guess.
Yeah.
But that's partly because legal privilege prevails over search and seizure generally. So so SARS would come and they would take stuff that they're allowed to in terms of search and seizure, but that doesn't include legally privileged documentation. So definitely some some provisions specifically around that.
Yeah. One thing just occurred to me as things do while one's discussing them. Maybe what one could do with a 2233 opinion is not disclose it in court when argument about penalties arises. But maybe you don't. That presupposes that understatement penalties is an issue before the court, and obviously the idea is to not have it as an issue before the court.
And we've spoken about, and I think that's
The
important.
line of least resistance is to disclose it.
Yeah.
Yeah.
We've chatted about the understatement penalties in the 223, and I think, again, worth pointing out that that's for substantial understatement. But unlike its name, substantial understatement is only a 10% penalty at a standard case. So it's the least of all the different items in section 223. Below, it's like reasonable care not taken, no reasonable grounds, impermissible, avoidance arrangement, gross negligence, intentional tax evasion. So I think important people think, I've got a 223 opinion, no penalties can be imposed. Well, it's only substantial understatement penalties that won't be imposed.
That's a very good point.
If they're going under GAR, impermissible avoidance range, we look down there, standard case 75%, and your opinion is not relevant there, your 223 opinion.
Yeah.
So I think that's, I think people, again, sort of overestimate the value sometimes of a section 223 opinion and in certain circumstances. And then the other interesting thing, Trevor, is that you have to say that the taxpayer's position is more likely than not to be upheld if the matter proceeds to court. That's quite a funny sort of language, that, because you sort of prejudging a court and a court process, and it presupposes when you give an opinion, you have some of the facts, but I mean, you don't know who the witnesses are, you don't have all the evidence. By the time something goes to court, you're in a different world.
No, absolutely. Just anecdotally, and it's perhaps not 100% in point, but in the Thistle Trust case, understatement penalties were an issue. And the taxpayer had an opinion from Meyerowitz in relation to a different taxpayer, but exactly the same point. And this Meyerowitz had been deceased for many years at that stage. But in his opinion, he said he knew that SARS disagreed with his view, but he thought SARS was wrong. And they actually argued that the taxpayer should have followed SARS's view because he said so in his opinion, that SARS's view was different. And the court had no trouble rejecting that argument. SARS cannot set itself up as the ultimate arbiter of what is reasonable and what isn't. Anyway, I found it strange that was even argued.
Yeah, you can't imagine Advocate Meyerowitz, because his opinions were, if you got 2 or 3 pages out of them, you were doing pretty well.
Yeah.
And there wasn't a lot of authority that was quoted. And I remember testing him on that, and he sort of fixed me with that glare of his across the desk. And it was like, I am the authority on these matters. I think he might have even used those words. These judges, they're all junior to me, he said. He was about 80, 90 at the time. Every
Yeah.
single judge was kind of, he saw as his junior come through the ranks of the advocates. So
Yeah.
he wasn't very, and if he thought something was right, it was just right. He didn't have to reason it out for hours and hours, the reference to lots of cases and things. He just, it was just right because he was Meyerowitz and he'd said so.
The only time he might reconsider his opinion was when, after half an hour, he took his hearing aid out and put it into his ear. Can you just repeat that, please?
But
I mean,
and
everyone laughs about this stuff, but it is important.
yeah, and you paid lovely tribute to him in the Taxpayer when you sort of passed on the Taxpayer as well, because he is one of our absolute legends and a privilege for us to have known
Yeah,
and worked with him.
yeah.
Um, I think, yeah, I think that was all from our side, Trevor. I don't know if you had any other aspects you wanted to chat about.
There's only one thing that had occurred to me. Remember last time we briefly touched on the Virgin Mobile case,
Mm,
where the
mm,
Supreme Court of Appeal held that if SARS is late with its Rule 31 statement and the taxpayer serves a Rule 56(1)(a) notice of application, which is the opening gambit for a default judgment, um, and that provides for a 15-day period, 15 business days. If SARS files its pleading within that 15-day period, they do not need to apply for condonation. And the court equated that more or less with a notice of bar in terms of the uniform rules of court. And then somebody pointed out to me in writing nogal that is somewhat unfair because Rule 52 provides that a party, so it's either SARS or the taxpayer, who failed to obtain an extension of a period of agreement with the other party, may apply to the court under this part for an order on good cause shown, A, condoning the non-compliance with the period, and B, extending the period for a further period that the tax court deems appropriate. So if SARS were to request an extension, then the rules say they have to apply for condonation. But if they just do nothing and the taxpayer forces the issue, then if they bring it within the 15-day period, they don't need to do it. That is odd. I understand that they have applied to the Constitutional Court for leave to appeal, and that the Constitutional Court hasn't considered it yet. So it'll be interesting to see what happens, because that is an anomaly, which I must say didn't occur to me the first time I read the judgment.
Yeah. And seeing more and more of those kind of applications being brought just because timelines not being adhered to. And at some point you can give extensions and agree extensions, etc. But at some point you need to get a decision. You need to get in front of a judge, and it's already hard enough with the long waiting periods, Trevor, to get court dates and the like, and you don't want things to drag on forever. So there's a reason for that rule.
And of course, SARS has no incentive to use Rule 52 because they've got their assessment. The taxpayer has to push the matter forward.
Paying our calculator as well. They've often got the assessment, got the money.
Yeah.
And yes, if they lose, they have to pay it back with interest. But in the meantime, they've got the money, and so as you say, it's often the taxpayer that kind of wants to push things forward. And hence all the stuff we talked about in the past about reviews and declaratives. That's always the taxpayer trying to move the matter forward, and proceed with it and get it done and get it finished. Even though SARS kind of often argues the opposite and says it's the taxpayer trying to delay tactics by going on the circuitous route, as opposed to following the tax court process. But in fact, it's often exactly the opposite.
Well, that's with respect, that's nonsense. I mean, it really is. It's the shorter route.
It's a shorter route. And you're entitled to follow it. If you've got grounds for review, that's why we have PAJA and declaratives as well. That's exactly why we have them. And now we've got that very long judgment on reviews.
United Manganese of Kalahari.
Yeah.
And I understand that the APSA case, which was one of the 5, that has now been heard. So we're waiting for judgment. And I think the other one, Lewin, is either it's about to be heard or it has just been heard. I'm not sure. I know it was on the list for hearing.
Mm.
Who knows how long we'll take?
Yeah.
We'll have to wait to hear. I'm sure
Yeah.
it'll be. Give us something to talk about next year.
Give us a lot to talk about because it's going to deal with the issue of reviews and declaratives and when you can go and when you can't go. And it was also a GAR case as well. So we're going to talk about tax benefit. What is a tax benefit? This is sort of the party point, in EBSA in that case, where they're party to the transaction, even though they just invested in preference shares, that needs to deal with that. And it might even touch on the question of purpose, although that would be overturned, whether purpose is a subjective or objective test. So Trevor has a bag of treats for us and tax practitioners. Just need to get it written now.
Yeah, I'm sure one of the issues will be whether the purpose test for GAR is objective or subjective. And something purely anecdotal, and no one's stepped out of line, but I communicated with the judge who wrote the Constitutional Court judgment in Capitec because I happened to have had a look at that case again, and the statement was made, this judgment concludes that SARS should not have disallowed the objection in full. So I made the point to the relevant judge, how can a judgment conclude? Surely it's the author of the judgment that concludes. But he didn't take any further. That really hits the point,
And there is a tax court judgment on GAR suggesting that the test may be more objective. I don't know, Trevor.
I've got that.
What's that
I
quote?
can't bring myself to read it. I'm sure it's nonsense, but with respect to the acting.
What's that? And what's that quote around your legal nerves?
My inner CJ once said, my legal nerves may be weak, but I must confess that this argument comes as something of a shock to
that line. I just cannot see how a purpose test is objective. And when people start saying it's more objective, I'm saying something's either objective or it's subjective. It can't be more objective. So to me, you're really conceding your argument. You say it's more than what? More than the Section 103 in 2006. And it talks about the arrangement, that an arrangement can't have a purpose, as I keep saying. Taxpayers have purposes. So I just cannot see how, the Constitutional Court or SCA will hold that's an objective test.
Yeah, and since we're on the subject, unplanned, Section 80, I think it's G, capital G. An avoidance arrangement is presumed to have been entered into or carried out for the sole or main purpose of obtaining a tax benefit, unless and until the party obtaining a tax benefit proves that, reasonably considered in the light of the relevant facts and circumstances, obtaining a tax benefit was not the sole or main purpose of the avoidance arrangement. How do you square that with the test being objective?
That's very true.
It's impossible.
That's very true. That's very true. So, Trevor, hopefully we don't have to eat
note on which to close it off for the year.
It's a very good note to close it off.
Yeah.
We will pick it up in January, Trevor.
Yeah. Have a good Christmas and a good holiday season, etc.
Yeah, and same to all of our
thanks to all of our listeners and audience who do take the trouble to listen to these things. We do appreciate it, and I know that plenty of people do. It's an increasing number.
Yeah, thanks, Trevor. Always good, eh?
Yeah.
Cheers.
Okay.
Cheers,
We'll
eh? Bye.
Bye-bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor Emslie and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.